Thank you for attending Sentencing Criteria as Crazymaker in Drug Cases. The event is part of the Understanding Drug Sentencing Symposium organized by the Drug Enforcement and Policy Center at The Ohio State University Moritz College of Law, the Academy for Justice at Arizona State University Sandra Day O'Connor College of Law, with help from Professor Mark Osler, University of St. Thomas Law School, and Dean Jelani Jefferson Exum at University of Detroit Mercy Law School. Before we begin, we have just a few notes we'd like to share with you. First, to streamline the appearance of the event today, we suggest that you hide non-video participants. To do that, click on the three dots at the top right corner of any participant box that has their video off and click Hide Non-Video Participants. Second, we want to draw your attention to the Q&A function at the bottom of the Zoom window. You may submit questions at any time during the presentation. Third, please note that auto-generated transcription has been enabled for this event. To change how you view the automated transcription or to hide it, click Live Transcript in the menu at the bottom of your Zoom window. Finally, this event is being recorded. The recording will be made available on the event page and social media channels as soon as possible after the event. Follow us at OSU Law DEPC to stay up to date on our research, programming, and future events. Thank you again for joining us, and we hope you enjoy the event. Mark?
Good morning. My name is Mark Osler. I'm the Robert and Marion Short Professor of Law at the University of St. Thomas in Minnesota. And as a teacher of criminal law and a former federal prosecutor, I often encounter people who are baffled by what they see in drug sentencing. What they're baffled by is the fact that the person who seems least culpable sometimes gets the same sentence or even a greater sentence than the person who appears to be most culpable. And that's often true, that if I was to go hire someone to pick up a load of meth down in Laredo and drive it back, and I was going to make $10,000 and I pay that person $500, if we're caught, we're both going to face the same sentence. And that's problematic and troubling. And we have some incredible experts today to talk about it from three very different perspectives. First, we're going to hear from Professor Mona Lynch from the University of California at Irvine. And she serves as the interim dean of the School of Social Ecology there. She has a long history in criminology. And she has spent years studying federal sentencing from the standpoint of somebody who understands data analysis and who is looking at this in an objective way and has seen many of the same things that those observers see, but also is excellent at explaining them. We're going to hear after Professor Lynch from Judge Nancy Gertner, who is a hero in law to many of us in this field, someone who has been teaching, advocating, and reaching out for decades. She's currently serving as a senior lecturer in law at Harvard Law School. She was appointed to the federal bench by President Bill Clinton in 1994. And Judge Gertner is one of the most important prominent voices in this area because she approaches it with a sense that's rooted in reality, but also with an incredible knowledge of the law and of the way that we got here. And it'll be great to hear from her. And finally, we're going to hear from Oren Ger. And Oren Ger is the director of research and also the director of the District Attorney's Transparency Analytics Lab and a policy advisor to the District Attorney in Philadelphia, Larry Krasner. And of course, many of us have followed what Oren Ger and Larry Krasner have done in Philadelphia, and getting the chance to hear from him directly about that experience and what they've done with full awareness of the problems that are going to be described by the previous two speakers, will really bring us full circle and hopefully give us some hope. And at this point, I'm going to turn things over to Professor Lynch.
Okay. Hi, thank you. And thank you for having me. I'm going to first share my screen. It's really an honor to be on this panel with such esteemed folks working in this field for very long time, having such an impact, and for being part of this larger symposium. Yesterday's panels were just wonderful. So let me see, share my screen. Here we go. that look good for everybody? Okay, so I want to talk about drug weight and how drug weight shapes sentencing in the federal system. I say the conspiracy of drug weight because really it is sort of unknown until you're in the weeds how much it has, that kind of the way that it has conspired to create incredibly long sentences and really with sort of malevolent effects. So let me begin with the just kind of an overview of what sentencing in drug cases looks like. So federal drug cases are and sentencing in drug cases is inextricably tied to the drug weight that is charged and or that can come in as relevant conduct. So when weight is charged in an indictment, if it reaches a certain level, it can trigger sentencing floors like mandatory minimums, which you heard about yesterday. Different substances have different triggering weights for those mandatory minimums. But drug weights can come in another way, and that's called relevant conduct. So the weight that's involved in that offense itself, even if it's not charged or even if it's not part of the conviction, can come in at sentencing to shape the sentencing guideline recommendation. So here's a sentencing table, and on this vertical line here from the offense level, that goes up and down, but depending upon the drug weight in a sentencing case. And these numbers inside here are the months of sentence. So even with the same kind of culpability and criminal history, the weight will drive sentences quite dramatically, as you can see on the sentencing chart. In fact, drug weight is so important that the U.S. Sentencing Commission now has two tools to calculate weight. They've changed their conversion or their way of sort of standardizing weight in recent years. And so they have the conversion calculator and the drug quantity calculator available for those who need to calculate weight. So that kind of tells you just how important drug weight is at sentencing. The interesting thing about drug weight is it's not as simple as one would think it would be. So there is actual drug weight, drugs that are actually seized, and the total amount of those weights can and will determine sort of what the sentencing range will be and or those mandatory minimums. These weights can include what some defenders in particular call sentencing entrapment weight, where say in a sting, somebody is sort of baited into making sales to reach certain kinds of thresholds to get to mandatory minimums. The second kind of weight that's actually really prevalent is what's referred to as ghost weight or historical drug weight, which is weight that say a confidential informant or a cooperator will testify that the defendant trafficked in or possessed. Then there's completely imaginary weight. There are certain situations where there's no drugs at all, there's no nothing to weigh at all, but rather something that is sort of stated by law enforcement, say in a drug stash house robbery sting, that then can affect sentencing. So, and it can affect actually mandatory minimums as well. So say a law enforcement officer says, hey, let's go rob the stash house. There's 100 kilos of heroin in there. That 100 kilos then can count as drug weight. That one is really sort of hard to grasp and to get your head around. And then finally, there's weight determined by a kind of conversion or other kinds of indicia of money or other kinds of indications of the drug trade, or kind of an extrapolation process from known information, say about somebody's drug lab and how much they could produce over what period of time. So this is sort of a way of assuming what weight was sold, sort of historical in a way, but it's really not using sort of testimony, but rather indicia to do this conversion. So there's three problems that I just want to talk about that come with this using weight as a metric. And the first one is I think pretty obvious, which is that weight is only loosely coupled with culpability, and checks on keeping low-level defendants from getting those long sentences are limited. There's a few things like like the safety valve. I think you heard about that yesterday in the mandatory minimum panel, which will get some people out from below it, but it really leaves a lot of people very culpable for and subject to very long sentences who really may not deserve it. And it doesn't distinguish well between sort of types of drug defendants when you use weight as your metric. The second, and this is the one I think that's a little less well known, is that the weight plays a huge shadow role in both charging and plea negotiating, providing prosecutors with really incredible power to do everything from kind of forcing a plea to discouraging legal avenues, certainly discouraging trials, and locking people into relatively long sentences to avoid even longer sentences should they go to trial, or should the prosecutor decide to, say, charge more weight. So because the charging in mandatory minimums really does dictate a sentencing bottom, a mandatory minimum in some drug cases, prosecutors have really a lot of power, even under the advisory guidelines, to sort of shape what the end sentence will look like. And they use that, and my research has shown that. Then third, the weight metric was really meant, and this is sort of the big project of the Sentencing Commission, was to try to standardize sentencing, but how weight comes in at sentencing varies both individually and jurisdictionally. So you see a lot of variation around how weight is used and abused in federal court. So just on the weight and culpability, I think the mandatory minimums are the best example of this. The one kind of relief, the safety valve, which got a little better under the First Step Act, still is not great at capturing those people who shouldn't serve very, very long sentences. And also there's a requirement that's sort of a tell-all requirement that actually is a deal breaker for some defendants, particularly ones who feel they're in danger by giving information about the case that they're in, or the circumstances of the case that they're involved in. In 2013, Attorney General Holder, who you heard from yesterday, implemented a policy that directed U.S. attorneys not to charge weight in a set of cases where the defendants would be considered low level. And that did help. And I'll show a slide here from some recent work that we did. And you can see here in this 2013 period, the proportion of mandatory minimum cases that received a mandatory minimum at sentencing went down during that period, but Jeff Sessions rescinded that policy, and you can see that mandatory minimum use went way up under the Trump administration. And we're not sure what's going to happen on that particular directive, whether that's going to come back under Merrick Garland. Second, in terms of the weight and prosecutorial power, here's where I think I was sort of most astounded in doing research on this, and particularly in the qualitative research where I talked to defenders and prosecutors and judges about drug sentencing. And here's where that historical weight or ghost weight really, really was both prevalent and really shaped what happened in terms of plea bargaining and so on. And I'm going to give you a couple of quotes here from two different districts that I spent time visiting and talking to people and making observations about how this works. So in the first one, a federal defender describes why it's really important to kind of go in and make a deal quickly, because the risk that the weight will get worse, and particularly as other people are going in and making deals from, say, a conspiracy case, that there's going to be more weight tagged onto the defendant. So that kind of creates this kind of rush to the front door of the prosecutor's office to make the deal so that things don't get worse on the weight. And in the second quote here, this is from the Southeast District, where I spent time talking to people and making observations in court. And I was embedded in a federal defender's office. And here historical weight was taken very seriously. And prosecutors would threaten to upweight if you even wanted to file a motion. So a defense attorney who had, say, in this case, a good Fourth Amendment issue for a suppression motion, the government would say, nope, well, if you go with that, then I'm just going to up the weight. And so that there's this kind of ratcheting up that was not seen in the final outcome. So this is all happening behind the scenes in terms of the negotiations around the plea agreement. And then the third example I just want to give is what I call the make-believe weight. And here, the kind of most notorious way this is happening is through what are called these reverse robbery of stash house stings, where law enforcement is really targeting particular defendants. And this is extremely racialized in most jurisdictions. And this was happening in the border district where I was embedded. In one of the large cities, sort of away from the border. It was sort of the only place where they were doing kind of proactive law enforcement, was setting people up on these reverse sting robberies, where the law enforcement agent would mention tons of drugs and would get these people to agree to go and do this robbery. There's no robbery, of course, there's no stash house, there's no drugs, there's no money, there's nothing. But since they talked about it and they agreed to do it, that was enough for conspiracy around that drug amount. And those folks would be charged with the mandatory minimum on top of other charges as well. Usually there'd be guns involved and they'd get them for the 924C as well. So in terms of variations in application, this is really what I kind of went into my work thinking about, how the U.S. Sentencing Commission tried so hard to regulate and standardize how sentencing happened, and drug weight was one of those ways that they did it. So it's really interesting in kind of seeing how that worked in practice, and it was sort of shocking how much things did vary on this. So there's a lot of variation about how much relevant conduct would come in, how proactive, say, the probation office was in seeking information from case agents and prosecutors on the weight, how much the judge would add, how sort of seriously the judge would consider, the evidence about the relevant conduct and so on. And I found huge differences between not only districts, but even divisions within districts on how this was applied. And as I said before, in the Southeast District where I was embedded, the relevant conduct drug weight was aggressively applied. And here's a quote from somebody who had moved from a Western district that was near the border to this Southeast District to practice. And she was a federal defender in both districts. And she was shocked to find out about the relevant conduct and how that was applied, and then how it actually drove sentencing. So for her to see how they use cooperators to drive up weight, even at sentencing, even after a plea bargain, there would be this weight added on, and the sentences would get extremely long. So here she talks about somebody getting caught with a $20 rock of crack cocaine, and all of a sudden they're getting sentenced on 300 grams or something like that on crack cocaine. And I saw this in court. I saw one person who was caught with 8 grams of crack cocaine, but through relevant conduct, the judge sentenced on close to 1,500 grams of crack cocaine. The person also was, when they busted him, they went into his house, they found a gun in the house, so he got an extra 5 years for the 924C, and ended up getting a sentence of more than 20 years in that case. And then I'm going to wrap up quickly here. My time's running out. In this case from the Southeast District as well, I'm really kind of focusing on how bad it was there. This shows how even when there's a plea bargain made between a prosecutor and a defense attorney, and they kind of agree to what the relevant conduct's going to look like, and they're kind of agreeing to what those terms are likely to look like at sentencing, the prosecutors can do, kind of end up giving information to the probation office beyond what's in what's called the statement of facts. that's supposed to lay out the things that the probation office would calculate in terms of relevant conduct. And they would, calculate that all of the stuff that they can find in the file. And in this district, there was also in one of the divisions in this district, the probation office would routinely call up case agents to try to see if the prosecutor was hiding information from them so that they could add to relevant conduct. And the judge and several of the judges in this district would take all of that relevant conduct and apply it and then stick to the guidelines or be very close to the guidelines in terms of sentencing. So with that sort of depressing ending, I'm going to just turn it over to our next panelist. Thank you.
All right, and thank you, Mona. That was fascinating. The stash house cases are particularly upsetting. I'm working on a project this year, in fact, with Katie Tino at Irvine and also Erica Zunkel at Chicago, where our clinic students are going to be taking some of those cases for clemency. We've got a couple questions up already, but I'm going to hold off on those and we'll circle back to them after all the panelists have spoken, because other people may have something to say on these issues. And I'd remind people too that if you have a question, there's a Q&A button down at the bottom. Just hit that and type in the question and we'll circle back at the end. And now we're going to hear from Judge Gertner.
I have a very odd presentation. And I have an odd presentation because it follows along with what Mona has done, because I wanted to talk personally about what it was like to be a judge in dealing with these issues. I'm writing a book about the men I sentenced, what it was like to be the judge in the position that Mona describes, for example. And I've met some of them afterwards. It's called Incomplete Sentences. And the reason I'm writing about it is, even though the federal sentencing guidelines are advisory, I am persuaded that what I've begun to call the habits of mass incarceration die hard. And when you are beginning to look at people in the way we've come to look at people, it's very difficult to unlook at them. So I'm going to describe a sentencing first, and then I want to take the points that we could glean from that sentencing, rather than, and this is an actual case that I've written about. It's the case of Damian Perry. He had no adult record. He was found with a small amount of crack, but he was part of a 30-person gang sweep. And under the guidelines, he would have been facing perhaps 5 years. Here's his background. His mother was 17 years old when she had him. She had descended into addiction and prosecution. And then his father was 15. By the time Damian was 3, his mother's substance abuse had progressed so far she was unable to care for him. He didn't see her again until he was 8, when he visited her for a weekend. She went to jail. He never saw her again. He had no contact with his father at all until much later in life. The addiction that had surrounded him on his mother's side and the fractured family led essentially to his own serious drug problem. He began smoking marijuana at 13, soon progressing to daily use, 13, beginning with marijuana. By 17, he was lacing the marijuana with crack. By 20, he was using substantial amounts of both. When he dropped out of school, he needed to deal drugs in order to support himself. Crack had hit Boston hard in 1988, replacing heroin. The street that he lived on was one of the first to have crack. And then there was violence. As Bruce Western writes, in poor families, people do not specialize in either victims, offenders, or witnesses when inhabits all of these roles. Damian's case was the most extraordinary. At 16, he was shot in the head. Accidentally, the newspaper said, but it wasn't clear from the facts. He lost his left eye and was hospitalized. The doctors could not remove pieces of the bullet because they were too close to a major artery. The fragments remained in his head, causing him headaches so severe he could not speak. He had hearing loss, blood clots, seizures. He had already suffered from depression because of his mother's abandonment, but after it got worse, exacerbated by post-traumatic stress disorder. His life changed. He was now a teenager with needs far too complex for his mother to accommodate. He skipped school, he dropped out, he started to deal drugs. The school that he went to was a school that had lost its accreditation. It didn't take much to drop out of it. And the psychologist reported that he was depressed, substance abuse, physical and emotional trauma, that he seemed to be impossibly compressed, he said, into 21 short years. Notwithstanding all of that, he had no adult record. Nothing that I had learned about Damien mattered. There was no box in the sentencing guideline for his abandonment, none for his depression, none for his drug addiction. There was no score for the unbelievable trauma of having been shot. I wasn't supposed to try to understand how likely it was that a long prison term would make his problems worse. All I was supposed to do, as Mona described, was to robotically total the drug amount he sold, figure out his criminal record, situate him on the sentencing grid, and pick a number. Let me say again, he had no adult record. He had never been in prison, let alone federal prison. I wanted to give him probation. This is 2005. I wanted to give him probation, but I knew that if I did, this is before Booker rather, that if I did, I'd be reversed, no matter how well I explained it. His lawyer argued for extraordinary physical condition departure. In the opinion I wrote on this, I said, Damien Perry has a bullet in his brain. Whether that's an extraordinary physical circumstance enough to warrant a downward departure, to ask the question is to answer it. Prosecutor wanted 14 years. Let me say that again. The prosecutor wanted 14 years. 14 years is what we use for transmitting, is a sentence for transmitting national defense information, assault with intent to murder, criminal sex abuse, kidnapping, an abduction. If that's what the guidelines require, I thought to myself, then as Oliver Twist, Mr. Bumble said, the law is an ass. How could one possibly justify that? There was a cooperating witness who would say anything to get out of a much longer sentence than what Damien was facing. He was 11 years older than Damien with a very long record. He had dealt in substantial drug quantities. His potential sentence was over 20 years. He was the one who testified that, oh yes, notwithstanding the fact that he was largely addicted himself, he managed to recall seeing Damien at specific times with specific quantities amounting to more than 50 grams. And that would get to the sentencing range the government wanted. Worse, there was then another cooperator also facing more time than Damien should have been facing, who said that he'd seen Damien shoot into a crowd. He'd seen it. This wasn't charged. There was no proof. It was one cooperator at a sentencing proceeding in which there were the evidentiary rules are loosened, telling me he had seen Damien shoot someone in a crowd. And then there was a pending gun charge, gun charge that I was supposed to take into account. The entire exercise, I wrote in my notes, was absurd. Sure, drug quantity may be a proxy for the question how big a dealer was Damien, but why should that matter to the sentence? Where did Damien live? With his grandmother. How did he live? A marginal existence. Where was he on the rung of dealers and suppliers? This guy who sold small quantities on street corners, who met buyers in a beat up bicycle. Did the accumulation of small sales on a street corner really show that he deserved the sentence the government sought? Sentences that I thought were reserved for drug dealers, drug managers and dealers. It got worse. That bullet in his brain, Damien insisted was really no big deal. No big deal. The government said essentially, after all, he had managed to deal drugs, notwithstanding that bullet in his brain. It was a version of, he did the crime, now you should do the time. He engaged in risky behaviors. I thought to myself that if this had been a white middle-class defendant, I would have gotten elaborate stories about post-traumatic stress disorder. We would have been appalled at the stories we were hearing. We would have responded accordingly, guidelines or no guidelines. The prosecutor would have responded accordingly. I sentenced Damien to 4 years. I gave him a 1-year departure from the guidelines as I had calculated him. For someone who had never been in prison, let alone a federal one, this was a substantial sentence. Before the guidelines, a 5-year sentence was huge. 20 years later, it was a gift. What do we learn from this? What do I learn from this sentencing? This is one of the 6 or 7 stories that I tell in my book. First of all, the guidelines privileged one factor, drug quantity, to the exclusion of virtually all others. You can't consider addiction is not ordinarily relevant. Mental health issues are not ordinarily relevant. Adverse childhood experiences are not ever relevant. You ignore all of the issues that prior to the guidelines would have in fact driven a sentence and should have driven a sentence. If I had gone on about those factors in his background, I have no doubt I would have been reversed. We privileged one factor, drug quantity, over all others. And why was that? Because the federal sentencing guidelines wanted to eliminate, not an illegitimate concern, wanted to eliminate disparity. And it was easier to pick a quantity that was objective rather than addiction, mental health, adverse childhood experiences, which were arguably would have introduced judgment into this setting, which would have meant my judgment would have been different than the judge in the courtroom next to me. Of course, we now know, I've spoken in other programs, I teach with the Federal Judicial Center and with the Center for Law, Brain, and Behavior about what we now know about mental health issues and drug addiction and the impact of trauma. We're not guessing about that. I am not simply being a knee-jerk Northern liberal when I talk about those issues. They are grounded in science, and we can sentence on the basis of them. We privilege disparity more than we privilege fairness, than we privileged proportionality, more than we privileged rehabilitation. We disconnected sentencing completely from rehabilitation. Damien's case was a classic case. We could have intervened at that moment in his life. There were things to have been done. He was only 21. The sentencing guidelines have enabled prosecutorial manipulation. Damien's lawyer had no idea when he was initially charged who in that group of 30 would rush to the courthouse steps first to cooperate. And of course, the ones who were the most vulnerable, the ones who were facing the most time, cooperated first, talking about quantity, talking about violence, etc. We've enabled uncharged conduct. Damien's case suggests I was supposed to increase his sentence because of a pending gun charge. And worse, we've enabled acquitted conduct. That is to say, if he had gone to trial and had been acquitted of whatever the quantity was, I was still supposed to take that into account in my sentence. I believe that drug sentencing has distorted advocacy, judging, prosecutors, even probation officers. It certainly distorted advocacy. When the guidelines became advisory, lawyers were still stuck then, as they are now, in talking not about the full human being in front of them, but talking about drug quantity, because they're obliged to calculate the drug quantity first under the guidelines before they can get to anything else. It has distorted the plea process, again, as Mona described, because whereas it always had been the case that when someone went to trial, there was a risk that their sentence would be higher if they went to trial, because you'd learn more at trial. Nevertheless, with the guidelines, there was a one-to-one correlation between any additional quantity that you learned of at trial, and the sentence you were obliged to give. And in that universe, where there's a one-to-one correlation between evidence of drug quantity and the sentence, even post-Booker, it privileges pleading guilty immediately to control the information that the judge gets. It's distorted advocacy, it's distorted trials. In my view, it's also distorted judging. Guidelines, advisory or not, make it easy to judge people by formula. Make it easier and quicker to dismiss people, to see the category and not the human being. And it certainly has distorted policing. the police in the Perry case knew exactly how long they had to wait on the corner to get to the quantity that would have triggered, in this case, not a mandatory minimum, but mandatory guidelines. I think it's critical that we look at this because it hasn't changed materially, although the guidelines have become advisory. I think it's critical that we go back to understanding what motivates people to engage in drug dealing, where they are on the pecking order, the difference between major dealers and minor dealers. And although that will introduce disparity into the system, information and training and peer review and analyses can address that. In any event, in this world, candidly, I would choose fairness over disparity any day. Thank you.
And thank you, Judge Gertner. As usual, you got right to the heart of what matters here. That's essential. And next, we're going to turn to Oren Gur for the perspective from Philadelphia.
Good morning, everybody. Thank you very much for inviting me to present today. Super honored to be on a panel with such esteemed presenters. I'll be speaking about progressive prosecutorial discretion as we enter the matrix. And that is an allusion both to sentencing matrices and also the movie and the idea that, there's lots of numbers involved in the matrix, and I'll be talking today about some of the data that we've been using in Philadelphia and some of the policies that we've brought about that I think, in my mind, mitigate some of the potential harms of sentencing criteria. So before I get started, I'll say my views don't necessarily represent those of the Philadelphia District Attorney's Office. This is my attempt to synthesize some of our efforts to date. So I'll be touching on progressive prosecutorial discretion more broadly, and then talk about less charging and bail and more diversion as strategies to mitigate those sentencing criteria. Plea offers and better plea offers are another example. And then finally, I'll touch on the relevance of information technology and data to some cases, Brady and Wardlow. So progressive prosecutorial discretion can be characterized by the increase in the past decade or more of prosecutors who have a different perspective and a different approach to engaging with the criminal legal system. So from left to right, you'll see State Attorney Marilyn Mosby to DA Krasner in the middle, and this is in the order that they came to be elected. These are just a few examples of progressive prosecutors as broadly defined. And at this point, progressive prosecutors account for roughly 20% of the population, or they have been elected in jurisdictions that represent 20% of the US population. So discretion is not new, right? It's not new in prosecution. It's not new in the criminal legal system. This is an article from the Yale Law Journal in 1960 that shows that there are these areas of no enforcement, right? You have substantive laws of crime, lots of areas of no enforcement. There's an absence of total enforcement. And as you go through the process, there are decisions not to enforce. And these are discretionary decisions that have been part and parcel of our system for a long time and are not new. And I think progressive prosecutors are wielding them a little bit differently than they have historically, with important implications for drug law. Now we'll get into less charging and bail and more diversion. So this shows the decrease in drug cases charged per month in Philadelphia. You can see in very light blue, right around here, 2018 is when DA Krasner came into office. Shortly thereafter, in February 2018, there was a policy memo released that included instructions to decline certain charges, such as possession of cannabis regardless of weight. Now, if you cover, the right side of this graph, you'll see that the decline hasn't been that great. It looks very steep because of COVID and efforts to reduce the number of people going into jails during COVID. But overall, the number of cases charged, drug cases charged, year-end counts, has stayed in, over 10,000 year to year in Philadelphia. So in spite of these efforts to decline certain charges and to do less charging, there are still drug cases charged in Philadelphia. This is a graphic from a paper by Orly Oos and Megan Stevenson, who evaluated our 2018 bail policy. And what it shows here is cases per week for these 3 different charges. Marijuana is clearly drugs, but these others are often associated with drug use. And what you see by this line drawn here is that relative to the policy memo that I referenced before, this February 2018 policy memo, there are many fewer cases being charged per week for all 3 of these. And you see a clear cutoff, a regression discontinuity. And then in January 2020 and January 2021, we also decriminalized possession of buprenorphine and fentanyl test strips as an attempt to, do less charging of substance use and harm reduction related material. So part of charging is bail and what our office requests and seeks for bail. This graphic here is an analysis of 5 years of data in Philadelphia, over 200,000 lead charges. In blue, you see the proportion of cases where bail was not requested or bail was not set at a monetary amount. So people would get ROR, released on their own recognizance. In orange, you see bail set less than $10,000. People would have to pay 10% of that to get out. Not everybody can do that. So there are clear racial disparities. And then in gray here, you see bail being set at more than $10,000. The stars here help see some of the drug-related charges. And basically the goal of our bail was to take all these orange parts of the graph and make them blue, right? So our ADAs, our bail reps, would not say anything in terms of what bail should be set at in these particular charges. And again, using outcomes from the previous 5 years, this is how magistrates were setting bail already. We could argue that if you're willing to set bail at such a low level, you might as well set it to release on your own recognizance or sign on bond, because setting bail at such low levels will have disparities. And that policy affected over 2/3 of charges and was effective. This is an example of the change in release on recognizance rates, and arrows going up show an increase in release on recognizance rates and blue going down. And this just shows that already in 2018, you see increases in release on recognizance rates for some of these drug-related charges. An exception would be possession of marijuana. Remember that the policy change there involved not charging smaller amounts. So that suggests that the balance of cases here would be more serious and larger quantities. So another way to reduce the impact of sentencing criteria is by doing more diversion. First, in February 2019, we put out a policy to expand accelerated misdemeanor program by removing barriers for entry. So people who had been in the program before, for example, could get other opportunities. Then in fall 2019, there was a more significant policy where we're dropping possession charges at first listing with proof of effort to connect to treatment. So if somebody is able to provide through their attorney proof of treatment, their case can be dropped at that very first listing. And here you see a graphic in the appeal that shows the proportion, the share of drug possession charges that have been dismissed or withdrawn by the Philadelphia DA's office over time. And I added this line to approximate fall 2019. So another really significant thing that you can do is give better plea offers. And these next few slides talk about policies we've put into place in an attempt to end what we call mass supervision. So this policy, there was a 2018 version, and then it was strengthened in 2019. The 2018 policy advised ADAs to seek shorter or no probation tails after a sentence of incarceration, and to seek shorter probationary sentences where no sentence of incarceration is sought. The 2019 policy gave more specific guidance. Counterfactuals were calculated to get a sense of what these particular numbers should be in order to achieve specific goals. So based on that, total supervision length should not exceed 36 months for felonies and 12 months for misdemeanors. And there was an office-wide average total supervision length established of 18 months or less for felonies and 6 months or less for misdemeanors. Here you see after the 2018 policy and then after the 2019 policy, negotiated guilty pleas have become more common under DA Krasner. So the proportion of cases that are resolved through negotiated guilty pleas has increased, both after the first iteration of the policy and again after the second iteration. And I should note this is work done by colleague Tyler Tran in the Data Lab and others, and you can access it at this link down here. Following the reforms, median supervision length fell for most negotiated guilty pleas, but not for downgraded pleas. So drug sales and aggravated assault are the two most commonly downgraded felony offenses, and they tend to be downgraded to drug possession and simple misdemeanor assault, respectively. So, you know, in my mind, there are questions about the implications of those types of downgrades further down the road, for example, when it comes to those sentencing guidelines and how they're applied. And this shows pre-Krasner, post the 2018 policy, post 2019 policy, and what you can see is like a stepwise reduction in the median supervision lengths. This again shows similar information, but it does it on a week basis. So each of these dots represents a week, and you can see how right after the policies are implemented in 2018 and then 2019, you see felonies in orange, downgraded pleas in gray, and misdemeanors in blue get in line effectively, right? So these longer sentences now become in this middle range in the case of felonies. And then after the 2019 policy, all of these, the median gets lower again, right? And it concentrates around these goals. Importantly, we found that racial disparities in community supervision through negotiated guilty pleas have lessened under these policies. So previously, Black defendants' community supervision sentences were 10.8 months longer than white defendants on average. And then over time with these policies, the average disparity was reduced to 5.2 months in the case of Black defendants. So you get a sense, and this is something that, you know, we find really important and plan to incorporate into all of our future work, but really looking for these racial disparities to be reduced and tackling that on its head. This just highlights some specific drug statutes and how the change in median supervision length pre-Krasner and then post each of the policies, and then the change over time. So, and again, this is in months. So pre-Krasner, it was 48 months of supervision for drug possession with intent to deliver. Post the 2019 policy, it's 24 for the median, and that's a reduction of 50%. So now I'm going to touch on Brady, Wardlow, information technology and data. So it's important to kind of explain at the Philadelphia District Attorney's Office, we're currently in the process of building a new case management system that will allow us to better do our work on the one hand, and also better have data for the work that is done. A lot of work in prosecutorial offices, this should come as no surprise to many, is done on paper. Ours is no exception, and we are trying to enter the digital age, and that creates all kinds of opportunities, right? So if you have a case management system, there are ways that information can be brought upstream, right? So similar to how some of these policies I've described have been upstream, things that can be done before sentencing guidelines are applied, you can also bring information using information technology so that it can inform ADA decision-making, discretionary decisions upstream. So I want to talk about briefly some ways that, one way we've been doing it, and then some other ways we've been thinking about that. So Brady versus Maryland, prosecutors constitutionally obligated to turn over evidence that is favorable to the accused, that is material to guilt or punishment. Failure to do so violates due process. Giglio, the court expanded that rule to include information that is relevant to the impeachment of witnesses. So with that in mind, our IT unit created a police misconduct disclosure database along with our conviction integrity unit. And what this does is at the time of charging, provides information to chargers in the charging unit of our office about prior misconduct, right? So they get an email, an automated email that's sent when an officer who's in the police misconduct disclosure database effectuates an arrest. They get an email outlining their prior misconduct, and that can inform their discretionary decision-making at the time of charging. That email is also sent at the time of subpoenaing. So ADAs throughout the office are aware when they subpoena an officer of anything that might be in that police misconduct disclosure database. Another idea comes out of Illinois v. Wardlow and writing by Andrew Ferguson and Damien Bernach. The idea that, you can use a high crime area to evaluate the reasonableness of a Fourth Amendment stop. So effectively, there is no standard definition of what constitutes a high crime area. Data can be used to create such a definition or to inform an ADA's decision about whether a stop did indeed occur in a high crime area. So similar to the PMD, the Police Misconduct Disclosure Database, there's the potential to bring that kind of information to lift it up so that ADAs, when they're reviewing each decision, can also be informed by patterns and trends. So this is just kind of one example of how this type of information could be brought forward to ADAs and could be used to inform their decision-making. This is an example of the racial composition of vehicle stops made by a particular officer. And you could use this to understand this officer's approach relative to others in their department, relative to others that work in their police service area, et cetera, et cetera. So furthermore, we know that there's legal discussions around how some of these issues come up, like the odor of cannabis in a stop and whether or not that can reasonably be used to effectuate a stop. And does it actually effectively uncover wrongdoing? Does it uncover illicit possession of narcotics? So here are some takeaways, some very broad takeaways. Policy changes in these areas that we've discussed can influence prosecutorial discretion in drug cases. You basically see that changing the policy did lead to changes in practice, did lead to changes in the graphics over time. Data allows for more specific policy guidance. You saw that with the ending mass supervision policy, and giving specific numbers led to additional changes and additional reductions. Similarly, bail reform increased the number of people who were released on their own recognizance. And then as just a good takeaway for the supervision reform, it reduced median length of supervision and associated racial disparities. It's really important to note, I didn't show data on this, but another takeaway should be that broad reform is possible without the sky falling. We did not see increases in pretrial recidivism or in recharge rates within 180 days for people in the supervision policy. We did not see increased failure to appear rates for defendants with the bail policy. So it's possible to make very broad changes without the sky falling. And I think that that just signifies that this is a great opportunity for reform. The last point has to do with progressive prosecutors and blue data. This is the last section that I spoke about with Brady, Wardlow, IT, and data. And what can you do with information that we have and that we generally use to keep track of defendants and people charged with crimes? How can that instead be used to inform decision-making and to increase accountability in the system? So just as a discussion, last points, the DA is one actor in the system. Sentencing guidelines are still going to be read in court regardless of what we do, for example. My idea here was that just as the cumulative impact of disparities at each phase can influence sentencing disparities, you can have this cumulative impact of policies that hopefully will lead to reduce the impact of sentencing guidelines that are overly punitive or overly harsh. The last point, and this is kind of what I think about on a day-to-day basis, is how do we use information technology, research data in a case-by-case world, right? We can inform, track, and evaluate policy. We can try to provide information upfront to inform ADA decision-making and state attorney decision-making. And that's what I spend my time doing. So I appreciate this time, the opportunity to talk. I want to thank all of my colleagues in the data lab, our Penn research team, and the DAO policy team who made all of this possible. And thank you. Look forward to questions.
Yeah, Well, thank you, Warren. And I think it's fascinating that you've got a district attorney with a data lab. That's something that we hope others will emulate and are emulating. And of course, this brings us full circle in looking at different parts of the system. We're going to be addressing some questions here, and I've got some that I want to throw out there, but there's one that came in that I think is particularly relevant to some of the things we've been talking about, which is, do the panelists have thoughts on how Congress could revise sentencing laws to address the weight issues that Mona identified? And this would go for state legislatures too. And this is something that I think all of us have thought about. What's a better way than using weight? I'm posting in the chat something I wrote in 2014 about using profit as a metric to determine culpability. But I'm going to go back to Judge Gertner. What do you think a better way would be to assess culpability than weight?
Well, in the past, weight would be part of the discussion, but the question was, the difference between the major dealer and the guy on the street was, is he living off drugs? I found this so many times in court, is he dealing drugs for the purposes of buying a Porsche, or is he dealing drugs for school supplies? And that is a different crime. We've made the illusion was that the crime was the same if the drug quantity was the same. And of course, that takes motive out of the picture in addition to the other factors I've described. So I actually would, it seems to me that we could characterize major dealer, minor dealer, have a set of characteristics that would be a broader range that the judge could take into account, of which quantity would be one. And then that would be part of the description part, and then we would eliminate mandatory minimums, which is clearly skewed to everything, and reevaluate from top to bottom the federal sentencing guidelines. Other than that, I'm fine.
Other than that,
Right.
yeah, I mean, it was always remarkable to me when I was a prosecutor how many of the people that were brought in as drug kingpins were indigent. They couldn't afford a lawyer. And that said to me that maybe this person isn't really a kingpin, or else they're an especially unsuccessful kingpin.
Right, but we can, it used to be, you'd ask the question, and when I was a lawyer, we used to do this, are you living off, what's your lifestyle? And what does that suggest about how important drug dealing was to you? And that matters. We took out motive out of the calculus because of quantity, and we took out all the other factors that I've mentioned. Just one other point about disparity. I think this was in Mona's point. When I sat for a month in Puerto Rico as a district court judge, and the cases that the Puerto Rican prosecutors would bring were not remotely like the ones that were brought in Massachusetts. The same quantity that in Massachusetts was a big deal was nothing in Puerto Rico. So the federal sentencing guidelines changed. The notion that we eliminated disparity as between districts was just not true. Not at all.
And let's turn to Professor Lynch. Do you have any thoughts on that? What would be a better?
Yeah, I think it's really challenging. One of the things that I argued so I wrote a book on my studies of the 4 different districts. Actually, I just focused on 3 in the book. But one of the things that's a problem is the headroom in drug cases, right? So it's the fact that things can get so awful. So the ceilings are as much of a problem as the floors, right? So there's you can hear me, right? Yes. Okay. So I think that's something Congress can address in terms of those statutory maximums, because those statutory maximums allow for that relevant conduct to go up. And then when you go into a district that's very bound by the guidelines, and there still are a number of districts, particularly in the South, where guidelines really matter to judges and they really stick to them. That's one issue. The other is really, I mean, part of it, the commission has to deal with it in terms of using that metric and thinking about, so I completely agree with Nancy's points about thinking about culpability as something, and also sort of the motivations behind it. I think the idea of the non-real weight is so problematic, particularly for relevant conduct, but because the burden of proof is lower, but it also affects the mandatory minimums. To me, it's was astounding to find out that this could happen. And, sort of knowing, particularly around the pressures on informants and cooperators to come up with things, the reliability is so low, and the sort of like blind eye to that possibility. So that, I think, needs to be addressed. Absolutely, in some districts, that weight is weight, because they're catching people moving drugs in a truck or whatever. In other districts, weight is that there's tons of weight that nobody's ever seen drugs, that spend years and decades and centuries for defendants who've been sentenced under this weight that doesn't even exist. So I think that part of it needs to be dealt with, but I don't know how. Sentencing Commission has a big role in this, as well as Congress addressing the statutory maximums as well as the minimums on drug cases.
I just want to interject. I would like Oren to work for the Sentencing Commission and ask the question, not what number can we pick out of the air, but ask the question of what works to eliminate the crime or mitigate the crime. In other words, he stopped asking the questions about deterrence and rehabilitation. We're picking numbers out of the air. And Oren, I charge you with doing that.
Oren, your response.
That's an honor. I don't know what, I can't say no. But I think there's many good people who are trying to do that work, and the instinct of using data, right? We have so much information at this point to inform, and I think that's always been the intent. But just as we keep going, you got to iterate and go back and see what the outcomes have been, so that we can create the change that we want to, right? Set those goals and create that change.
Okay, and Oren, just before you go on mute here, most of the drug cases, of course, come down in the states. What would you want to have change in Pennsylvania law to make your work to get things to be more equitable?
Yeah, that's a great question. I mean, in my mind, and again, not speaking on behalf of the office, I got to be careful about that. There's just far too much churn in this area. And to the judge's point, is this necessarily helping people to respond to substance use in this way? I think based on all the research, or much of the research that I've seen, the answer is no, it's not necessarily a very helpful approach. So I think it would just be complete overhaul of how we approach substance use, and that should also occur through changes in the law, because you can't just count on discretion of an elected official, because that can be very ephemeral.
Yeah. Okay, thank you. And I want to go, there's a question about disparities between judges, which of course is always an issue, and kind of highlighted in a recent analysis by the Sentencing Commission on compassionate release that showed that in the Western District of North Carolina, 1.5% of the cases there were granted, whereas in Oregon, it was over 60%. So, disparity between judges is important. And of course, disparity between prosecutors has been really important as well, something that's hidden because they don't operate in the open in the same way. So of course, anytime that we talk about moving away from mandates, we enter the discussion of how do we control disparities between judges. And I guess we'll go back to you, Judge Gertner, on that to address that question.
Well, let's pretend that judges were like every other discretionary actor in the system, prosecutors and police. Every other discretionary actor, we are trying at least to look at their exercise of discretion, let's say on racial grounds, by studying it after the fact and saying to this police officer, you have only picked up Black people, or saying to this prosecutor, the racial disparities are enormous. What if we did that with judges? Well, enhance discretion and then have after the fact analyses of whether or not that what not just did you sentence under the guidelines or not, the binary question, which is really all the Sentencing Commission typically asks, but the more fulsome discussion is what issues did you credit and why? And do that after the fact, share that with the judge. And that's one way of dealing with discretion. The other way of dealing with is in other settings, we talk a lot in Federal Judicial Center and the Center for Law, Brain and Behavior of the equivalent of peer review. There's a period of time before the guidelines when there were sentencing councils and judges would get together and say, what do you think about this guy? What do you think about this guy? In other words, how do you deal with a discretionary actor in order to make sure that the differences are not dramatic? And there are other discretionary actors. What we've done with judges, what we've done with nobody else, which is to say, you must do this. You know, it's mandatory to do that. And I don't think that that works. The problem with the disparity studies, both the Sentencing Commission and the one recently published by Syracuse, is that it implies that everyone should default to the guidelines. In other words, everyone should default to the guidelines, that somehow the reason for the disparities is that not everyone's a guideline center. And finally, the Sentencing Commission could post on its website examples of what judges have done in paradigmatic cases as a way of encouraging other judges to do that. The Sentencing Commission posts on its website guideline compliance. And so the judge that wishes to diverge from the guidelines is at sea. So there are lots of ways of cabining discretion, but I could go on.
And of course, the guidelines were designed to adjust to what judges were really doing. They just never implemented that part of their mandate. That was supposed to be a big part of it, and
Right.
It never actually happened. I was wondering, Professor Lynch, do you have any thoughts on that question of interjudge?
Yeah, I do. I mean, first to your point that there's equally, if not more, discretion going on in prosecutors' offices, not only, particularly in drug cases where the decision to even prosecute is completely hidden and kind of uber discretionary, right? The kind of targeting, particularly in places like Boston, where they were going to certain neighborhoods, looking to sort of pick up the bad guys who, we can't get them on other things, so let's get them on drug stuff, where that stuff is not regulated and it's completely hidden from us. So there's no obligation that prosecutors share their data about what they're doing. What's happening in Philadelphia is a very rare thing to have open data around this. And certainly that would be one thing, is to kind of think about the discretion. And most of what we're seeing, like when we do analyses of the kind of multi-stage discretionary actions, we see a lot happening that affects sentencing that's really those early stage decision-making stuff. And you just, and to pin it all on a judge is to sort of conflate what are a number of decisions that happened before then. And I did some qualitative work around the question of what happened after Booker. And prosecutors would tell me, oh yeah, as soon as Booker came out, we're gonna start threatening mandatory minimums to get the deals we want with and to kind of cabin the judge, particularly on like child porn cases. Like, oh, we'll charge the mandatory minimum if you don't go along with this deal, because we know this judge is like really sympathetic to these and thinks the guidelines are too long and so on. So that kind of stuff that's happening behind the scenes and at earlier stages gets wrapped into those disparities, and it all gets pinned on the judge, which is, to me, unfair. It's really not just a judge's decision.
Yeah. Before we run out of time, I do think we need to talk explicitly about race, something that comes into this. I'm going to start with you, Warren, because you did in your PowerPoint explicitly address racial disparities and reducing them to some degree. How do we get to actually eliminating racial disparities in these kinds of cases?
Yeah, I think that goes back to, the very heart of the laws and how a lot of these came about, and the intent and just the history of drug law enforcement in our country, and the very first laws passed here to target opium dens on the West Coast. And, it's at the very root of it. But I think what the reason I remarked on that in particular is because there aren't that many studies that can identify those types of reductions, especially when you're doing reform. Often you see that as you reform systems, disparities can become even worse, right? Like as the jail population has gone down in Philadelphia over time, some of the racial disparities and disparities in terms of people with mental health conditions who are in jail, those just get worse. The proportion of, people with serious mental health issues in jail has increased over time as we've tried to reduce the jail population. So I think, those are examples of endemic problems that we have. And I think, part of the solution is to do the math, look at the data, and specifically craft policies that take the disparities, take the racism in the system head on. And I leave it to lawyers who know better if you can actually do that, right? There are some potential limitations there. And that I think is also, problematic, or maybe that's, again, just the system and how the system works to kind of limit the ability to take these issues head on. But that's the key, I think.
Yeah, and I definitely want to hear from our other two panelists on that. I know Professor Lynch will start with you next, but you've written extensively about racial disparities and the creation of them and some types of crimes. What is our way out of that problem?
Well, it's, the drug, I think for the drug war, we'll call it what it is, that has been racial as we just heard from Oren from the start, and it gains its power through the ability to sentence people to a long time and to manipulate people into doing things like becoming confidential informants and so on. So there's, of course, there's incentives built into policing around, and this is documented at the state level, local level, and even down to misdemeanors into, going out and doing proactive drug work, because there are certain things that come with it. There's things like, forfeiture and so on that have this kind of ugly history in our country. But in the federal system, which I've been studying the most, I've actually studied some kind of frontline policing in the state system, but at the federal level, it's really that uber discretionary stuff that started in the 1970s, right? By opening up this ability, the kind of federal jurisdiction over what are really state and local cases, that kind of opened up the possibility of the feds going after low-level drug dealers, and then that opens up the possibility of using that to sort of develop, networks of confidential informants and cooperators and so on, and kind of create this monster. So I think that the incentive structure for going after drugs in one of my districts, the Northeastern district, the very liberal district, judges would refer to the small drug cases as low-hanging fruit. They're super easy for prosecutors to make. The conspiracy law in the federal system allows for really easy cases to make and generating lots of defendants, getting numbers up and so on. So the solution to it is less regulation of drug and less punitive regulation of drugs. And what that looks like across all the many jurisdictions. Let
me just let Judge Gertner close us out on this. I know this is something that's informed her work.
Well, it's as if the judges in this system were the caboose, and all of the decisions have been made long before the caboose. And so the question is, what can a judge do at the end of the line? Mona is talking about prosecutorial decisions and legislative issues. That's one thing. What can a judge do at the caboose? If you gave me more discretion to sentence, I may be able to examine more carefully issues like selective enforcement. I may be able to examine more carefully issues like sentencing entrapment. I may be able to ask questions of the prosecutor, as we're asked in Chicago, about a stash house that was contrived by the government and put in a Black neighborhood. I did a little bit just trying to deconstruct the guidelines. I wrote a decision on driving while Black, and I wouldn't credit what was clearly a traffic offense that only a Black man in this jurisdiction would have gotten. So if there are obviously many more changes at the front end, but clearly, if you tie a judge's hand so that we really are the caboose and all we're supposed to do is calculate drug quantity and criminal record, there is no way we can examine these issues. So I want the caboose to have more power.
Thank you. I think that's a fine place to end since we're out of time anyways. But I'd really like to thank our panelists. I think this was a fantastic discussion, and I just wish we had more time. And going forward, I hope we will. Thank you.
Thank you, Mark, and thanks
Thank
everybody
you,
for
Mark.
coming.
Thank you so much.
Thank you.
Byron,
Great to be on the
thanks.
panel. You take care.